Abel and Baker are able to give their kids $102,000 without having to file a gift tax return and without having to pay a gift tax or report it. So I would say very common in wealthy families. They are making some type of annual gift to the kids. And again, $100,000, if you have a larger estate and you say, well, that's just not a lot of money. Well, if you do this and an interfamily loan and you do these other things we're talking about, collectively together, if you do this over time, it can be a lot of money. And we have an example of that. So Abel Baker. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've got over 25 years experience. We have offices throughout California. I am a certified specialist in estate planning, trust, and probate law, a real estate broker, securities insurance licensed, and a third-generation pilot. These are the lawyers in our firm. We are dedicated to helping families get peace of mind through multi-generational estate planning, as well as planning for wealth and protection and all those things. So if you're watching this on YouTube, go ahead and subscribe to our YouTube channel. We're doing a live webinar, and we do these typically Thursdays at noon Pacific time, and then we post them typically later that day, Thursday. And so these are on our YouTube page. If you have never seen our YouTube page, I really recommend you check it out and go ahead and click and subscribe. Disclaimer, I'm a lawyer. I'm talking. Words are coming out of my mouth, right? This is absolutely not legal advice. You watching this does not create an attorney-client relationship. The bottom line is don't watch this and go out and do a bunch of stuff because I talked about it. So when is a gift taxable? Well, if you make a gift directly to an educational institution or medical provider in any amount, these are not gifts. So if you're paying someone's hospital bill or paying their college tuition, that is not a gift. If you're reimbursing them for tuition, that is a gift. So you really have to be careful and pay attention to that. You can give a gift to a U.S. citizen, spouse of any amount. If your spouse is not a citizen, it's capped at $175,000. Basically, the government doesn't want you to be married to somebody that is not a citizen of the United States, and you give all your assets to your spouse, and then your spouse goes back to their, the country they're a citizen of and never pays federal death tax. So that's what's going on there. And for 2023, it's $17,000 per person, meaning I have 3 kids. I can give $17,000 to each of my 3 kids, and there's no requirement to file a gift tax return. We think that's going up to about $18,000 in 2024. This is indexed for inflation. And if a taxpayer does make a taxable gift, which is anything that I've not described here, a Form 709 must be filed. That's the gift tax return. And for 2023, if your lifetime gifts do not exceed $12.92 million, excluding, gifts to spouses and gifts of $17,000 or less, it is 40% on amounts over $12,920,000. We don't see that a whole lot in practice. People just really aren't doing that, given that the numbers are so high. So let's look at an example of Abel and Baker. They have 3 children, Charlie, Delta, and Echo. At Thanksgiving, Abel gives $17,000 to Charlie, $17,000 to Delta, and $17,000 to Echo for a total of $51,000. Baker does the same thing. Abel and Baker are able to give their kids $102,000 without having to file a gift tax return and without having to pay a gift tax or report it. So I would say very common in wealthy families. They are making some type of annual gift to the kids. And again, $100,000, if you have a larger estate and you say, well, that's just not a lot of money. Well, if you do this and an interfamily loan and you do these other things we're talking about, collectively together, if you do this over time, it can be a lot of money. And we have an example of that. So Abel, Baker, and Charlie have their 3 children, Charlie, Delta, and Echo. Abel and Baker created an irrevocable trust in 2013, which is 10 years ago. They make a gift and what I did is I went back here and they gave the maximum amount you could give without incurring a gift tax. And as you can see, if you're watching this on video, then their total gifts are adding up now to $1.1 million. So they made this habit of giving, $80, $90, $100,000 a year. And then I just put it in the S&P 500. And now you've got 1.1 million set aside. So 978,000 is given, but it's 1.1 million. And that's kind of through the end of the quarter of end of September. So actually we're in October. I said we were in September, we're in October. So this is very, very important because this is a strategy that works over time. And the concept I'm trying to share with you is if you do this as a habit over a period of time, then Abel and Baker have gotten $1 million out of their estate, which is a significant sum of money. Now, let's say Abel and Baker say, well, what if we bought some life insurance with that? So what a lot of people do is they will use a trust and they will put money into this trust and buy life insurance. So in this case, we did a 1, 2, 3, 4, 5, 6, seven premiums of $84,000. And the death benefit is about $1 million. So in this particular case, they were to take, they put money in, and if one of them passed away, if they both passed away, then they would get a death benefit that goes to the children. But here they paid for 7 years and they've got $1 million death benefit. So you put in, a lot less than $1 million, and that $1 million, by the way, passes free of income taxes. So this is very, very important. Life insurance passes free of income tax. Life insurance pays out when the death tax bill becomes due. Life insurance pays out when people die. Death taxes are due 9 months after death. These are aligned in terms of when that liquidity happens, and then that gives you sufficient liquidity to then effectively pay the taxes. And there's a little bit of a detail I'm omitting, but basically that money is available to pay tax. So let's say they do both. They invest in life insurance and S&P 500. If they just did a straight investments, it's 1.1 million. If they did the life insurance surrender value plus the investment, it's 1.2, and a death benefit plus the investment is 1.4. So either way, however you slice it, it's really, Abel and Baker in this case, it really did make sense for them, because they're not missing that money, to put that in a trust, because now it's outside of their estate. And after 10 years, you've got a significant pile of cash there, significant transfer from the parents to the children. Let's talk about discounted valuation. This is very important, and we're going to get to this when we start talking about trusts. When mom makes a gift of 1/3 of an interest in Greenacre to Sonny, so mom's got Greenacre, it's a piece of land, and she gives it to Sonny, the third can be discounted, because what's taxed is not the value, it's not the property, it's not what mom has, it's what passes to Sonny. And if somebody gives you 1/3 interest in a piece of property, you probably can't sell it, because no one buys 1/3 of property, right? And you can't control it because you only have 1/3 vote. So there are discounts available for lack of marketability and lack of control. These typically can be as high as 35%. Now, these are combined with LLCs and partnerships, or family limited partnerships is kind of the old schooler way of doing it, and intentionally defective grantor trusts, which we'll talk about. These discounts can be as high as 35%. So what am I talking about? What I'm talking about is many people out there can gift almost $20 million in assets, 19.8 million. And if you have a 35% discount, you are taxed at 12.92 million. So let me say this another way. When Sonny gets the gift that the government agrees is valued at $12.92 million, it's actually $19.8 million in value if everything were sold, right? So it's a way of getting assets to the next generation for less than essentially the full value, hence the term discount. So this is discounted valuation, and this works for certain asset classes. Real estate is one of them. Potentially a family business does not work as well. You're not getting nearly this kind of a discount for marketable securities. So great potential strategy, something to pay attention to. Irrevocable grantor trust. Now, this is not make work. I think some people think, oh, lawyers just make things complicated. It's been, there was an Italian philosopher who said, I would have written a shorter letter, but I didn't have enough time. This type of planning is measure 19 times and cut once. It is highly individually tailored to each person that we have as clients, because really no two situations are alike. And as you go through this, you'll see what I'm talking about. So what is an irrevocable grantor trust? Well, a revocable trust means you can amend it. You can revoke it. An irrevocable trust means you cannot amend it and you cannot revoke it. Doesn't mean you can't modify the terms, separate term, separate issue. But if it's irrevocable, it cannot be amended, it cannot be revoked. The creator of the trust on an irrevocable trust no longer owns the assets. The trust owns the assets. The trustee is in charge of the trust. The trustee has control of the assets. The beneficiary, who gets what's in the trust, has essentially the ownership for our purposes here. But ownership doesn't really matter, because, when the president's occupying the White House, that's the people's house, right? The president does not own that house, gets to use it. And so it's a similar thing is, if that president's voted out of office, someone else is coming in there, that individual person doesn't control it. In the same way, if you're a beneficiary of a trust and not trustee, you're along for the ride. The trustee's in charge, the trustee's in control. The creator of the trust, for the trust we're talking about here, this grantor trust, irrevocable grantor trust, the creator of the trust, the grantor, is deemed the taxpayer of the assets and property that go into that trust for income tax purposes because of certain provisions in the trust. Now, this is really, really important. And I think this is one of the things that people really struggle to understand is how can I give something away and still be deemed the taxpayer, meaning I'm stuck with the tax bill, right? I put something into an intentionally defective grantor trust. I don't own it anymore. And let's say we sell it or there's income. I have to pay the tax. Like that stinks. So, but it doesn't. You'll see why that's not necessarily a bad thing. The creator must pay the taxes on any income, but the assets aren't part of the owner's estate, which is really kind of weird. You can have a provision that the trustee has discretion to reimburse the grantor. So, if the grantor doesn't have any money or doesn't have enough money, the trustee can have discretion, but you can't say that the grantor shall be reimbursed because then it defeats the whole point of the plan. So these irrevocable trusts that contain one or more Internal Revenue Code Section 675 powers are very important to understand, meaning that the person who created the trust is deemed the taxpayer. Little technical, but this is also for lawyers. So we get a lot of lawyers watching these and our staff. But the 675 power is very important. Power to deal with assets for less than adequate consideration. If the person who created the trust has the power to buy, exchange, or dispose of trust assets for less than adequate consideration in money or money's worth, that means that the grantor is deemed the taxpayer. Also, the power to borrow money without adequate interest or security. If a grantor says, "Hey, I'm going to put $1 million into this trust, but I want the ability to borrow it without having to pledge security," that means that the grantor is deemed the taxpayer. It's kind of a penalty, but we're flipping this on its head and making it a benefit. The general powers of trust administration held in a non-fiduciary capacity. This is kind of the power to vote stock or control investments, and the power to reacquire trust assets or substitute property of equal value. Very important, because when if this is called a swap power. Now, this may preclude the grantor from serving as trustee, but if I put property in there and I'm like, wow, the property I have isn't going up as much as the property in there, and I know that property in that I have, it might be going up a lot more, and the property that I've given away kind of isn't going up as much or has this future, I can swap those out so that the appreciation goes to the next generation. So very, very important concept to understand. That's called a swap power. There are different acronyms we use. These are variants of the same thing. An intentionally defective grantor trust, you might hear that or see that. All that means is that it is taxable to the grantor. I really don't like the term defective because clients go, why am I getting something defective? That's weird. A GRAT is a grantor retained annuity trust, another type of grantor trust. A dynasty trust, which we'll cover separately. A spousal lifetime or limited access trust. Spousal lifetime access trust or spousal limited access trust. We'll cover that separately. But this is very important to understand. When the grantor dies, the trust becomes a non-grantor trust. Now, why does this matter? Well, it matters a whole lot. And for that reason, typically it's one grantor, one trust. Meaning if it's a married couple, oftentimes those spouses will each have their own trust. You might have one trust for the 3 kids, and then the other spouse has another trust for the same 3 kids. You really don't want to do a single trust for both, because then the trust becomes half non-grantor and half grantor. And there's a lot of, again, this gets legal technical, but I just want to give you a heads up that if you pursue this type of planning and you're married, it's very likely that each spouse will end up with their own trust. And you may think you're getting over, it's a lot of make work on the lawyer's part, but that's actually the right thing to do. Situs. Situs is very important. Situs means where does the trust live? Irrevocable trusts are created under state law. You could create an irrevocable trust under California law. You could create it under Nevada law. Why would you pick one state or another? Often the states with the most favorable asset protection, favorable inheritance provisions, and no state income taxes, that's really key, are states that many people cite or locate these trusts in. And sort of the top states are Nevada, Wyoming, South Dakota, Alaska, Delaware, and New Hampshire. We frequently choose Nevada as the state for to do an intentionally defective irrevocable grantor trust. And we use Wyoming for when we do a Wyoming close LLC for a lot of different kind of nuanced reasons. But many times we're using a Nevada trust, which means you should have a Nevada trustee. So that does increase the fees associated with it. But Why does it make sense to go out of state? Well, first of all, no state income tax, right? So this is if the trust stops being a grantor trust when the grantor dies. You're not going to be subject to state income tax. And also the creditor protection. You know, if you give something away to somebody, you don't want an ex-spouse to come in and take that. And so that's that creditor protection. Also the term of the trust, and we'll talk about that in a couple of slides. I did mention this irrevocable trust tax burn. What am I talking about this? If you just give an asset away, right, just to a person, you don't have these attributes. So if you use an irrevocable grantor trust wrapper, what's the benefit? Well, you put that same asset into a trust and then there's a tax bill due. Well, instead of the beneficiary paying the tax bill, you pay the tax bill as the grantor. So you're the person who set this trust up, gave the asset away, put it in this trust, you pay the tax bill. Why is that important? Because as you get closer to death, you want your estate to get smaller, because anything that's in your estate, if you have a taxable estate, 45% death tax. It makes sense if you're going to pay the same tax, like just the baseline case. If you're going to pay the same tax or the next generation is going to pay the same tax, it makes sense for the older generation to pay the tax, because if the younger generation pays that tax, they don't have that money. And then the money that otherwise would have gone in tax, you got to pay 45% when a person passes away. So it just makes sense to have this trust tax burn. So this is the grantor paying the trust. This applies to trust created October 4th, 2004 and later. Again, this under the Obama and Biden administration, they want to get rid of this. So you really need to move on this before it goes away, because who knows what happens in elections, right? Tax burn example. Grant creates an irrevocable trust for Sonny, gifts $1 million of XYZ stock with $100,000 cost basis. And Grant retains the power to add a charitable beneficiary. That's another power you can add to make it a grantor trust. So when the XYZ stock is sold, Sonny gets the $1 million where it's in the trust, and Grant's stuck with the tax bill of $300,000. This is effectively an extra $300,000 gift to Sonny. All right. This is the taxes are burning Grant's estate. And this is a great strategy for people who believe they will live a long time. This is a bet to live strategy, as Robert Keebler so artfully put it. This is a bet to live strategy. If this were a bet to die strategy, we might have done a self-canceling installment note that goes away when Grant dies. So if Grant said, hey, I'm only going to live a couple years, we do the self-canceling installment note. But if Grant says, hey, I'm going to make it to 110, then we would be looking more at the gift strategy and burning the tax burn. You can also do a sale and a gift. And I know I'm getting a little down in the weeds, but it's important for you. If I'm going through this too fast, just if you're watching this recorded, just go back and take a look at it again. Let's say Grant creates an irrevocable trust for Sonny and retains the power to add a charitable beneficiary, gives $100,000 in XYZ stock, and sells $900,000 in stock. Now, because Grant is the taxpayer, there's no realization of capital gain. And he takes a note for 4.11%. The XYZ stock returns an average of 14.11%. So the math is easy. This is $1 million in profits to Sonny over a year. Well, Sonny keeps that. Grant's trust has paid Grant $702,000 in interest, tax-free to Grant. So the tax interest is tax-free coming back. And in year 20, the $900,000 principal is returned. So basically, Grant is renting this stock to Sonny, and Sonny now has $4.6 million. And this is after paying the interest and returning the $900 principal, right? So this is effectively a wealth transfer. So if this, you could have private company stock if you own a business. A lot of people do this if they own a business, if they know, gee, we're getting about a 14% return based on this interest in the business. Let's go ahead and lend that, right? And then have that come back. But all that extra 10% on that million year over year goes to Sonny, and Sonny now keeps a lot of money. Let's say Dad's healthy but doesn't think he's going to live very long. He gives $12.9 million in company stock for the benefit of his daughter. We covered this, and sells the remaining $10 million of company stock for a note. The note carries a mortality risk, as we mentioned. There's no capital gains tax. In that prior example, there was capital gain, right? But in this situation, there's no capital gains tax because he is selling it. It's like if you sell something to yourself. So what Dad's doing is Dad is, as an individual, has this stock or in the company stock, and he is selling it to a trust that is taxable to Dad. So there's no realization of capital gains tax. Dad pays tax on all the income, but not the skin payments, because that interest is, he's paying tax on the income in that trust, but the self-canceling installment note payments are not taxable. And the trust makes 2 payments of $545,000. Dad dies, no death tax, right? So this is an example. Instead of just giving it all and paying a gift tax, you do the self-canceling installment note, right? Because dad is going to live shorter. So again, if this is a little confusing, go back and take a look at it. As I mentioned, I think these are in the crosshairs with certain administrations. Both the Obama and the Biden administration want to end grantor trusts. And I'm not making a political statement. This is a statement of fact. So you can be a Democrat and love Biden and Obama and understand if you're wealthy, this planning strategy is going away. So that's just something to be mindful of. It may go away. It's on the chopping block. It never quite gets to the chopping block or gets its head cut off, but it is on their radar screen. Private annuity, again, this is another sort of a bet to die strategy, I guess you will. Allows you to move an asset out of your estate in exchange for annuity payments. So Granny, age 95, transfers $10 million to Sonny in exchange for annuity payments. And when Granny dies, the payments end. So this is also based on your actuarial life expectancy. So those might be big payments, but understand this is why I'm saying that sometimes death taxes can be optional. So private annuity can be a very useful strategy. Dynasty trust. So what are we talking about here? We're not talking about the TV show. Think of a dynasty trust as a long-term locked treasure box. Okay, this is a box that's passed from generation to generation. You can't, if you pick the right jurisdiction, creditors aren't going to be able to attack it. No divorcing descendants, spouses. Future descendants, ex-spouses can get access to that money. And what a lot of people do is they will work with a lawyer, create a dynasty trust, and will move assets into that trust during lifetime. Right. So what we're talking about here is the dynasty trust that's created during lifetime, and you can put 12.92 million in there. And this is no gift tax. Couples can transfer 25.84 million. Now they might be using separate dynasty trusts, but they can transfer a total of 25.84. This money, if you pick the right state, like Nevada has a 365-year term, this trust can go on for 365 years. That money under current law will never be taxed when someone dies, again, just because they pass away. Now you might have income tax, but it's not going to be subject to a death tax. Now, again, there are in Biden's proposed budget from last year proposed to end this so that this only lasts as long as all the people named in the trust are living. And then once the last person dies, it could be 100 years. Once that last person dies, it is taxable. Many of these strategies, by the way, do end up getting grandfathered in. I don't know if this one would get grandfathered in or not, but if this is you, if you're like, yeah, we'd like to put 13 million or 26 million into a trust and never have it taxed again. Yeah, let's do it. You're probably not going to do it in California because California's maximum term is 90 years. You're going to be picking another state. You might have to have a trustee and a professional trustee in that state as well. So there's a little bit of care and feeding. But how do these work? The dynasty trust always owns the assets, right? Not the individuals in any generation. They are beneficiaries, so they can get distributions. There's no tax on the distribution. I mean, there might be setting aside income tax, but there's no tax based on that distribution, the money going from the trust to the individual beneficiary. And depending on how the trust is written, the person making the gift can be the trustee and maintain 100% control, but sometimes not. It depends on how these are written. So if you create this trust, sometimes those people stay on as trustee, but sometimes they don't, but then they have other powers. And I really don't want to get in the weeds on that, but just know that sometimes you're trustee and sometimes you're not. Once these assets go into this locked treasure box, they're not part of your estate, no death taxes. And there is also, not only can you put 12.92 million, you can give somebody 12.92 million, you can put 12.92 million in a trust that skips generations, that opts out of the generation skipping transfer tax. So what this is if you say, hey, I'm wealthy, I'm going to skip my son and leave it to my grandson, that the government taxes you again on that. So if you try to leave money to someone 37 and a half years younger or 2 generations, it's a duplicate, it's another tax. So how this works is if I have a 10 million taxable $10 million transfer, 40% taken out in taxes. So that leaves 6 million. And then another 40% on the 6 million is taken out. So another 2.4 million. So it's a very taxing endeavor. You really want to avoid the generation skipping transfer tax. It's something to be mindful of. But with a proper dynasty trust, estate taxes only need to be paid once when the trust is funded, if at all. After it's funded, that money can be used for future generations. And this is the example we covered. Grandma gives 22.92 million to grandson, 10 million is taxable, and the tax bill is 40% on the the 10 million, and then another 40% on the 6 million. So a lot of taxes, very, very taxing. Situs, again, many dynasty trusts are not cited in California. If you're a California resident, states typically, again, it's a state that has no income tax, favorable creditor protection, and long life expectancy. States that have long trust life expectancies, meaning you want to have it, more than 100 years. California is not one of these. Alaska, South Dakota, Wyoming, and Nevada. These other states have eliminated something called the rule against perpetuities. The rule against perpetuities says trusts cannot go on forever. Well, South Dakota's eliminated that. Right? There's no federal, by the way, there's no federal property law. And a lot of people don't know this. Property, what is property, is defined state by state by state. Okay. And that has our own unique legacy in the United States. And what property is not a federal question. It's always a state question. And South Dakota has said you can have a trust that goes on for 1,000 years. Nevada says 365. So it's better than California, which is 90. Spousal lifetime access trust. What are we talking about here? This is a really powerful tool. So in 2023, Able creates a spousal lifetime access trust under Nevada law and puts $12.92 million in it. Beneficiaries are Baker, Abel's spouse, and their 3 children, Charlie, Delta, and Echo, in a common trust while Able and Baker are alive. So what happened? This is a trust where one spouse gives money to another spouse, but in a trust, so it's outside of both spouses' estates when the spouses die. Okay, so when Able and Baker are dead. So Able says, you know what? I'm going to give a bunch of money away, and I'm going to have my spouse, Baker, and my kids, Charlie, Delta, and Echo, all beneficiaries of what we call a common trust, or a pot trust, P-O-T, common trust, pot trust. When Able and Baker die, when the parents die, property is divided into 3 separate trusts for Charlie, Delta, and Echo, and they split the sheets. They go their separate ways. 3 dynasty trusts. Okay, it spins off. The property passes free of estate tax and death taxes, and this is even though the value, this could grow to $50 million. Passes free of estate tax, and they save millions and millions of dollars. Able doesn't get anything out of this. And so when they go out to dinner, who's paying, Able or Baker? Baker's going to pay, right? If they need some money to live on, maybe Baker makes that withdrawal. And then Baker can, you would not put this in the trust, but Baker can do anything Baker wants with the money, even help out Able. Now in 2025, Baker creates a Wyoming dynasty trust. So remember, Able in 2023 created a Nevada spousal lifetime access trust. Baker creates a Wyoming dynasty trust and puts $12.92 million plus inflation in it. The beneficiary, so this is Baker, the other spouse. The beneficiaries are Able and Baker's 3 children for the life of Baker. Well, and this one we might do Baker's 3 children for the life of Able. I think that's how that should be written. And it's significantly different than Abel's trust. We're trying to avoid the reciprocal trust doctrine, and we'll talk about that in another slide. When Baker dies, Able becomes a beneficiary with Charlie, Delta, and Echo in a common trust. Yes, so this is the beneficiaries are Baker's 3 children, not Able. So Baker sets up a trust. Abel's not a beneficiary. Baker's 3 children, Echo, Charlie, Delta, and Echo, are the beneficiaries. When Baker dies, Able becomes a beneficiary with Charlie, Delta, and Echo. Kind of steps in to be a beneficiary. And then when Able and Baker die, the property is divided into 3 trusts for Charlie, Delta, and Echo. The property passes free of estate and death taxes, even though it grows to $50 million. If you are in a community property state, you will need a postnuptial agreement, which means the couples typically come to one. If a couple comes to our firm, we're going to say each of you, Able and Baker, needs to go get your own lawyer and do a postnuptial agreement. Otherwise, this won't work. And a lot of people go, well, this is ridiculous. This seems stupid. It's not stupid. It's a requirement. So each spouse has to retain separate legal counsel. And again, the attorney handling the estate plan for the individual, for the couple, will not handle it for the spouses. So this is a big deal. The reciprocal trust doctrine is a judicially created principle that is designed to deter estate planning where 2 trusts are created equal. So if Able and Baker on the same day with the same lawyer, each did spousal lifetime access trusts that are the same terms, the IRS is going to say, no way. If it's separated in time, you go to separate counsel. That is how, and the trusts are different. That's how you can not get stung by the reciprocal trust doctrine. So this is real. And there are cases before the tax courts where this has been applied. So you got to be really careful with this. And and really know what you're doing. Very important that you use a three-legged stool. With this, remember the A team, right? The attorney, the CPA, the financial advisor. These three professionals need to work together. If you have assets of over 10 million, we have a multifamily office. So this is where you basically hire our firm on an ongoing basis, and we're paying attention to all this stuff. So if you go, oh, I set this up, I don't understand anything, we can help you. Or if you have this set up and maybe your lawyer's retired and you don't have a lawyer, give us a call and we can help you with that. We also have my book, Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer. We do cover a lot of the, not so much the tax issues, but the basic estate planning issues. We have offices throughout Northern and Southern California, and we are also meeting a lot of clients on Zoom like everyone else. Next week, we have planning considerations for business owners, and this will be with Christina Lindsay Orta. Very, very important. If you're a business owner, estate planning is even more important. So I think you understand why. And the link is in the chat. And if you're watching this on YouTube, please subscribe to our YouTube channel and click the bell. You will be reminded when these come up, when the videos are released. We will open it for questions. If you are watching this on YouTube, just keep watching because another video is going to roll right after this one.